Hello, everyone. Welcome to another Agenda IDS. I am Patrícia Porto. I'm the academic coordinator of Daneman Simpson Institute. Agenda IDS is an online event in the form of a roundtable discussion in which we address important topics regarding intellectual property, law, and technology. I was invited experts in the subject to share their experience. Those who miss the event today will be able to access the record content later available on the IDS website. And today, in celebration of the World IP Day, we will discuss the topic Amendment to Patent Claims, Global Updates. This is a very hot topic that will be discussed by an international team of experts from Brazil, India, and Germany. And now, please, let me introduce our guests. To discuss the issue under the India regulation, we invite Mr. Ankush Verma. Mr. Verma is a lawyer and patent agent. He's a managing associate at Hemfren & Sagar. He holds a dual master degrees in chemistry from Rutgers University, United States, and from University of Delhi, India. From Germany, to talk about the topic as regulated by the European Patent Convention, we have Dr. Alexander Wirwal. Dr. Wirwal is an engineer, patent attorney, and partner at Winter Brandel. He holds a PhD degree in engineer, a master degree in mechanical engineer, and an LLM in European IP law. He's also a member of the International Federation of Intellectual Property Attorneys, FICP. To talk about the subject from the Brazilian perspective, we invited Mrs. Monique Rodrigues Teixeira. Mrs. Teixeira is a pharmacist, industrial property agent, and partner at Daneman Simpson. She's a patent specialist training by the Japanese Patent Office and the Asia-Pacific Industrial Property Center. And as the moderator of the event, we have today Mr. Ivan Bacela Aller. Ms. Aller is a mechanical engineer, industrial property agent, and senior partner and chairman of the board of Daneman, Simpson, Bigler, and Ipanema Moreira. He is also a member of the Council of the International Federation of Intellectual Property Attorneys, FICP. I really would like to thank each one of our guests for being here with us today. Now, I will give the floor to Mr. Ivan Aller. Thank you very much. Mr. Aller.
Hello, everyone. It's an honor to be here. I have to start with an apology because my partner Gustavo Moraes, who was supposed to moderate the session, had the last minute change in the scheduled meeting with a client. So here I am, and let's hope that this will work okay to everyone. It's a great honor to be here with Alexander, who I have known for many years now, with Mr. Ankush Verma. I have read a decision where he represented Allergan before the High Court in Delhi, in which was a very important decision in India. I hope we'll have a chance to chat a bit about this, and also my partner, Monique. And I'd like to start by asking the question, which answer must be known to most of you, which is, why is it important for an applicant to be able to amend a patent application during examination? If we think about another situation like filing a trademark application or a design application, in those cases, the object of the protection is reasonably outlined from the outset. There's the trademark, there's the design, the discussion about what is being, what's aimed to be protected is relatively limited. When we talk about a technological invention, the issue is completely different. For those of you who are used to drafting patent applications, we know that this is a hard phase to exchange information with an inventor, first to understand what the new technology is, to try to extract from the inventor what are the possibilities to implement this invention besides the one or two or three or that he is envisaging at that point. So when the application is filed, the idea of what is really a patentable invention is something still a bit fluid. It's not something set in stone or not close to what a trademark or a design are. So the thing is, when will the applicant be ready to really determine what is the best way to claim his invention? In my opinion, is after the examiner has issued an opinion, and this is his opinion, which is different from country to country, about number one, what is the closest prior art in his or her opinion? And second, what is new and inventive on invention which is disclosed in the application? Only then will the applicant finally know, okay, that is the person with whom I will negotiate the best way to claim my invention. If at that point is not able, the applicant is not able to fully resource to his disclosure of the invention, it may be difficult, if not impossible, to get a proper protection for the invention. So that's what we are going to hear about how it is handled in Europe on the European Patent Convention as applied by the EPO, in India, and in Brazil. And so I'd like to turn the floor to Alex.
Ivan, thank you for giving me the floor. Let me take the first thing I want to say. Thank you for getting me on the floor, for allowing me to speak together with Monique and Ankush. Thank you also to Patricia for organizing this all. You touched a very crucial point from the European point of view, because from my experience, everybody who came into contact with the EPO notices that it's probably the strictest, I will use this superlative, the strictest office in the world concerning undue amendments. And it's very, very important that you stay within the framework allowed by the articles, rules, and the guidelines and the ruling of the court, and to avoid that you spend or your client spends a lot of money for a patent, and then at the end of the day he loses or she loses it. I would like to share my screen. We tried it up front, it worked. Let's try it again. And I will go to the presentation and go on full screen. Let's see if it works. I hope you can see it. The most important article which we have in the EPC is the article 123.
Alex, sorry, but we have again the two screens, have the bigger one and the smaller. Perhaps it's better to go back to the other presentation form, because then we have a larger image. Yeah, I think we can work with that.
Okay. Then you probably see the slide I'm talking about in the middle, and on the left-hand side, you still see very small slides, which I'm going to speak about later. Is this correct?
Yes.
I'll try to make it as big as possible for you. Like this. Well, this article 123 EPC is the most important one, and I will take a few minutes or a bit of time to explain. Well, the first part of this article and that's important to know, is it rules that you have at least one opportunity to amend the application from your own volition. That means whenever you have used this opportunity, it's up to the EPO to decide if they allow another opportunity. Normally, from the past, I would say they allow it. But just keep it in mind that there may be a point in time that they don't allow it any longer. In the usual processes, after the second office action, they will send a summons for oral proceedings, and then you could discuss it orally with the full team of patent examiners. That means 3 examiners. The second and probably most important part of this article rules that the European patent application or European patent may not be amended in such a way that it contains subject matter which extends beyond the content of the application as filed. We later will come to the reason why, but just in short words, that's the gold standard which we refer to here. Namely, we give at the end of the day the client or the applicant a monopoly for something which we in Europe understand is not a very good thing. So we try to avoid monopolies on the one hand side. On the other hand, we allow a patent, which is a monopoly, but then only for such subject matter which is novel and involves an inventive step, and therefore brings the technique up front so everybody can benefit of it. That's a grounded idea of patents as such, and that's so that every third party can prepare him or herself. We have this second part of Article 123 to forestall that something will be patented which has not been disclosed originally. And the third part of this article is also an important one, especially if you think later of opposition proceedings, namely that a European patent as such may not be amended in such a way as to extend the protection it confers. So we have in Germany and Europe, we have a decision after we have granted the patent. We have to be careful that if we do amendments, we do not extend the protection. So first in the application process, we shall not amend in such a way that we extend to something which has not been originally disclosed. And later on, we also have to be careful that we, even if it's disclosed, do not extend the protection. When we talk about those 3 items of Article 123, then we have to use the eyes of a skilled person, because the great board of the EPO ruled about 20 years ago that we have to look with a skilled person eyes on it to judge if the subject matter of the claim can, and that's important now, directly and unambiguously be derived using the skilled person's general common knowledge. So if you read a few of those rulings, even the recent ones, you will probably always find a referral to this skilled person, and then it's directly, and that it has to be directly and unambiguously derivable. So whenever you do some amendments, that's what you have to keep in mind. So when you think about what is directly and unambiguously derivable, for sure, what is literal disclosed, for example, in the claims or in the description, all that we call explicit disclosure. You may also refer to implicit disclosure. For example, if you can clearly and unambiguously see it with a technical eye in the figures, the drawings, no problem should be at that. But be aware that it's directly and unambiguously disclosed. This will probably be discussed. The EPO, when they were set up, 70s, 80s, they came up with some guidelines, and it's always helpful to refer to those guidelines to get some feeling how they live this Article 123 and this decision of the Great Board of Appeal. So that's why I have enclosed this link. A few rules also have to be kept in mind. I have listed them, and this already brings me to two most important topics going along with it. First of all, if you have the feeling you have an explicit disclosure for your amendment, that's good, but you should take care that it's not an intermediate generalization, because that's what you normally tend to do. You have a disclosure of something, and then you would at least broaden it a little bit. And the question is, what can you do to broaden it? And the answer is not much. You should avoid to do this, and even be careful that you use it in the context as it is disclosed. So if you have some singular disclosure for something, then you should take care that the feature is not related or inextricably linked to any other features, because if this applies, you will have to also include it in the claim. And the overall disclosure justifies the generalization in isolation of the feature only in seldom examples. So that's what you have to keep in mind. And I already said that the EPO, at least to my opinion, is the strictest office worldwide. This strictness even shows itself when you would like to delete features, like you had feature A, B, C, D, and now you want to delete feature D and include feature E instead. Then you probably will have to do the so-called essentiality test and find out and show that the replaced or removed feature was not explained as essential, and that it is not indispensable for the function, and needs no modification from any other features involved. If you cannot show those three points, that's why it's also called 3-point test, then you will probably not be allowed to do so, as it is contrary to Article 123. So this probably will see a little bit weird to you, because the applicant, of course, is allowed to make amendments which he thinks or deems necessary, but with this framework, they show until which border you may amend your claim set. So I hope this already answers what are the rules. And Ivan, do you want more?
Alex, yeah, I would like to ask you for a clarification. If you can go back one slide, I see that there is a difference in the flexibility of amending claims when we are talking about a pending application.
Yes.
When you have a granted patent.
Yes.
So I'm not sure if it's clear that the second slide you're talking about a pending application or a granted patent. Because this is one point which is very important for us in Brazil. I think it's the same in India. with respect to being able to not only, I see here, item 3, the European patent, this is a granted patent, may not be amended in such a way as to extend the protection it confers. This is the whole issue about broadening the scope of pending claims. I understand that if the patent is already granted is one situation, if it's still pending is another. So the restrictions you commented on the third slide, are they related to a pending application or to a granted patent?
Well, from the logical standpoint, first of all, Article 123 concerns amendments whenever they are done. And then, for example, if you have a look at the first and the second paragraph, they both concern applications and patents, both. So only the third one concerns the patent. So whenever you are talking about amendments, you will have to fulfill Article 123, paragraph 1 and 2. So that's applicable in the application stage and in the patent stage. So the G decision is applicable in the application stage and in the patent stage. Same also for the intermediate generalization and for the essentiality test. That applies always. On top of it, you have 123 paragraph 3. This concerns only patents. So this then comes on top.
Okay. Yeah, good. Well, let's say that in the interest of time, perhaps we should move forward to Mr. Werman, and then later we'll come back and discuss about the usual advices related to amending an European patent application. So, Mr. Werman, let me place the question that I should have made to Alex. How are amendments to patent claims ruled in India? What are the conditions stipulated by the Indian Patent Act to amend the claims of a patent application regarding the scope of the amendments and the time limit to do it? You have the floor. Thank you.
Thank you. So I'd like to first thank Dr. Porto for the introduction, and truly it's an honor and a privilege to be able to share some of my thoughts on claim amendments and the evolving jurisprudence in India, and to be doing it on the eve of World IP Day. It's like the cherry on the cake. So this is, of course, a very important topic. I'd like to briefly mention, I mean, we have a provision which is somewhat similar to Article 123 of the EPC. That is the provision of Section 59 of the Patents Act. As it stands, it's actually a little complicated. But before I get to, and that's actually the provision that talks about the nature and the scope of amendments. But before I just touch upon that, I think a couple of the provisions which are just before Section 59, which is sections 57 and 58. They also deal with amendments, and they lay down the procedure and the timelines. And since that's a fairly easy topic to get to, I think I'll just quickly go over that, and then I'll come on to the focus more on the nature and scope aspect. As far as the procedure goes, it's a fairly straightforward procedure. Whether it's a pre-grant amendment or a post-grant amendment, there's actually a standard form that's called Form 13, on which we make the amendments. It's actually a request. It's a request to the Patent Office to make voluntary amendments. It basically contains certain bibliographic details, but more importantly, I think what's really important in the form is you have to specify the reason for making the amendments. So it could be one or more reasons, which could be, and it could be as simple as something as a correction of a typographical error, or a correction of an obvious mistake, or maybe perhaps you're introducing new claims to explain the invention in a more lucid manner, but some reasoning needs to be given. It remains the same whether it's pre-grant or post-grant. Essentially, there's no time limit which is fixed. So, when you want to make voluntary amendments, typically that can happen soon after filing of the application. Now, filing is a bit tricky because Section 57, and you look at the other provisions of the Act, when you file an application or you enter national phase in India, typically you're not allowed to undertake amendments. So you have to file an application with the original PCT claims or the claims that have been amended under Article 19 or under Article 34. If you want to make any amendments, you will have to file that formal request on Form 13, and whether that concerns merging the claims or whether that concerns adding new claims, only deletion of claims is permitted at filing. So that might be at variance with some of the other jurisdictions. So that's typically what happens at filing. Post filing, like I said, there's really no stage essentially when you need to request. So you're given a certain time frame. You have about 17 months after you've entered national phase to request examination of the application. Clients and applicants generally choose to make some voluntary amendments at that stage, and that's looking at some of the amendments which have taken place in counterpart applications. And then you could essentially, even after, so a first examination report or a first office action is issued by the Indian Patent Office. That is essentially the time when you could request for amendments, and you don't really have to file the formal request. So you could do voluntary amendments, and you could justify the amendments as being in response to the objections which have been raised. So very similar to Article 123(1), except that you're not, it's not voluntary. It's in response to we call it that you're responding to the objections in the first examination report. Post grant is slightly trickier. It's more difficult. I would say that, obviously when you file this formal request, there's an official fee component which is associated, and that sort of doubles up after post grant. And if the amendments are substantive after post grant, they will be published in the official journal of the Patent Office. Once they are published, there's a 3 months opposition window which is given. So any person who is interested in opposing the amendments can do so in writing to the Patent Office, and you have that 3 months window. And then, of course, once there's an opposition, the controller will hear both the parties and then finally decide whether the amendments should be allowed or not. So that's pretty much as far as the procedure and the timelines are concerned. Now I'll come to Section 59 straight away in the interest of time. Section 59 is actually a very ambiguously worded provision, and it's somewhat similar to Section 123, but it's, like I said, given that it's ambiguously worded, it's sort of difficult to sort of decipher what the lawmakers actually intended. And so if I were to distill that provision down, I'd say there are 3 main features, or there are 3 main elements to that. First is that the amendments have to be in the form of a disclaimer, a correction, or an explanation. It's interesting that the term addition does not find mention here, and that's typically when you're adding claims, you hit into an objection under Section 59 with the Patent Office because they say addition does not really fall under one of the 3 categories, even though you may try to explain, you try to tell the Patent Office, it's by way of explanation. It's very difficult to convince them when you're trying to add new claims. So that's one part. The second part of Section 59 states that it's the amendments have to be for incorporation of an actual fact. Now, what exactly does incorporation of actual fact means? That's anybody's guess, because it's, again, like I said, it's very ambiguous. What is not an actual fact? I think that's something that the courts might deal with in due course, but definitely not happening right now. The third and the most important part, it says that amendments to claims must fall wholly within the scope of the claims prior to the amendment. Now, and this is something which is similar, I won't say identical, but something similar to what Article 123(2) of the EPC states. But again, what does this expression fall wholly within the scope mean? That's essentially what was somewhat clarified in the judgment that I was that one of the matters, that I'd argued and I was supported by a wonderful team with me, the Allergan decision that you had rightly mentioned. This particular phrase was interpreted to essentially state that claims cannot be read in isolation. So you have to look at the specification as well. So when you're looking at ascertaining the scope of the claim, it's not just the four corners of the claim. Apart from that, you've also got to look at the disclosure. So I'll leave that bit of discussion for a little bit later, but I hope that's try to clarify what the procedure, the timelines, and what the nature and scope are as far as Indian law are concerned.
Ivan,
I think you have to audio to put the audio.
Yes.
You're mute.
Yeah, that's the most usually heard sentence. You are in the mute. Okay. So thank you, Ankush. And Monique, now you tell us what are the requirements to amend patent claims according to Brazil's industrial property law, please.
Thank you, Ivan. Thank you, Alexander and Ankush. It is a very pleasure to be with you all here today discussing a very important issue. And regarding your question, Ivan, the single, I will share my slide first. I just forgot. Can you see my screen?
Yes.
Okay, so the single provision contained in the Brazilian IP law related to claim amendments is contained in Article 32 of our Brazilian law, which defines that in order to better clarify or define a patent application, the applicant may perform amendments up to the request for examination, provided that they are limited to the subject matter initially disclosed in the application. So upon reading Article 32, we find a very important administrative step and the prosecution of a patent application in Brazil, which is the examination request. And in Brazil, the examination request can be performed up to 36 months counted from the effective filing date and from the international filing date for PCT applications. So said article can be considered as ruling amendments filed before the examination request. Therefore, in view of the language of Article 32, and as the Brazilian IP law does not contain any provisions for submission of amendments during the examination on the merits, it opens the door for different interpretations of Article 32. And you see on my screen, the pyramid shows three possible interpretations given by Article 32, a restrictive one, an intermediate one, and a reasonable one. So we will begin with the top, which is the restrictive one, in which the understanding is no amendments can be submitted after the examination request. So in view of the language of Article 32, it is understood that no amendments could be submitted once the request for examination has been performed. And this is the argument usually used by third parties when submitting aid for examination of patent applications, that is pre-grant oppositions or post-grant oppositions. And the intermediate one is the interpretation in which the understanding is after the examination, only restrictive amendments are acceptable. And this is the interpretation used by the Brazilian PTO. And according to this interpretation, the right to broaden the scope or to include new embodiments, that is, claim categories, is seized once the examination fees have been paid. And the third one, which is the green one, the basis of the pyramid, is a reasonable one that we consider it is our position and the applicant's position, is that understand that after the request for examination, amendments to claim the matter disclosed in the application are acceptable, since it is written in Article 32 that up to the request for examination, amendments can be done, provided that they are limited to the subject initially disclosed. So this disclaimer of Article 32 of the matter initially disclosed in the application is used to this interpretation that once the subject matter claimed is disclosed in the application, so the amendment should be accepted. And we are talking about voluntary amendments submitted by the applicant. And Ivan, may I continue?
Yes, please.
Just to explain how the Brazilian PTO is interpreting and applying these rules about amendments and to patent claims in examination.
Yes, please go ahead, Monique.
Okay, so as I have mentioned, the first point to be observed in the administrative step of examination request, which refers first to the mere payment of fees for the number of the claims on file, which you wish to have them examined. And according to the Brazilian IP law, any submitted with the aim of adding new categories or broadening the claim scope in relation to that was originally filed or originally claimed are allowed until the request for examination. Any amendment is possible if supported by the application as filed. And this administrative step, the examination request, is effectively deemed to be a waiver of unclaimed matter. That is to say that if the application supports subjects that are not covered by the claims on file at the time of the examination, then you no longer be able to include them if you have already paid the examination fees. So, for example, if you have in your set of claims, compound claims and composition claims, and the application discloses other categories such as kits, use, article of manufacture, and any others, the applicant should consider including such claim embodiments in the set of claims before the request for examination, because after the examination request, only amendments directed to the restriction of the claims on file at that time are accepted. So in your screen, you have the deadline of what I just have told you. You have the filing date, international filing date for PCT applications, or the filing dates for non-PCT applications. And before the request for examination, any type of amendments is possible, obviously, provided that the amendments you wish to pursue are supported by the application as filed. Once you have paid the examination fees, so your right to include or to broaden the claim scope is seized, according to the intermediate interpretation that I have shown in the previous slide. So non-acceptable amendments after such administrative step is that new claim categories and broadening of the claim scope. And a point that is important and should also be emphasized here is that the Brazilian PTO adopts the same position, the same approach for divisional applications. That is, if a division application has to be restricted to the subject matter of the parent application as claimed before the request for examination. So if you have filed the request for examination and for certain embodiments, and you have the intention of displacing some subject matter into the division application, so it is very important, and the applicant should be very, very careful in including the set of claims at the time of the examination request, all possible embodiments, categories, the broadest claim possible, so that during the prosecution, you can perform the appropriate restrictions and even elect or displace the subject matters to pursue in a divisional application. I know that although all the administrative fees are paid for the filing of each divisional, such as the filing fees, the annuities, the examination request fees, the Brazilian PTO considers that once the request for examination of the parent application has been filed, such effect is brought by the divisional application. And just a final comment, Ivan, just to mention that there is no specific provision in the law addressing the submission of voluntary amendments after the granting. But during the administrative nullity procedures, the Brazilian PTO may decide for the partial nullity of patents, suggesting any restrictions or even cancellation of specific claims. So the letter's patent is reissued with annotation to the letter's patent containing the suggested amendments which the examiners has considered to still subsist after the nullity procedures.
Okay, thank you, Monique. Just before we move to the common question I want to place to the three of you, Ankush, let me ask for a clarification. You see that in Brazil, there is a difference between the allowed amendments that you can make before the request for examination and after. Is there such a distinction in India too?
No, actually, I mean, it's if you are trying to, it's advisable that if you want, you know, typically, like I said, what generally happens is that any amendments which are considered by most applicants or clients is they take place along with the request for examination. So you know, it's actually a good time to consider if you wish to introduce some claims. Of course, you know, there's always you always anticipate a Section 59 objection for any new claims that might be added. But if you are looking to introduce some claims with new aspects, which perhaps have not been covered in the original PCD claims or at the time of filing, you could consider doing that at the stage of examination, at the stage where you're requesting examination. And, you know, depending on, I mean, it could be, it's a double-edged sword, so to speak, because if the controller determines that the amendments, and of course, it again comes down to that Section 59, that phrase which says falling wholly within the scope. So if you're trying to alter the scope, there is a possibility that the controller, who is the officer at the patent office, he may not consider the amendments at all. So there is that risk of introducing new claims. But it's certainly possible to do that at, you know, at the stage of requesting examination. But it's not really that the new subject matter cannot be introduced. Of course, the threshold to overcome Section 59 is it just gets more and more difficult the later you try to introduce new claims.
Yes, okay, thank you. So now I will place the same question to the three of you, and I will reverse the order now. I'll start with Monique. What is the usual advice related to the submission of amendments to the claims during examination?
Okay, Ivan, amendment is obviously a resource guaranteed to the applicant as a normal part of the examination of a patent application and is submitted for a different purpose, or that is to overcome objection raised, to voluntarily restrict the matter in order to expedite the allowance. And considering the importance of amending the claims during the examination, since in the patent system there is no second chance, the submission of amendments is very essential. So as previously mentioned, the applicant or the attorneys shall be very, very careful when deciding amending the claims by including in the set of claims, by including categories or broadening the claim scope at the time of the examination request. And we always advise that please consider including all embodiments, categories. Please consider including the broadest claim possible, so that during the examination you'll be able to perform the appropriate restrictions, or even to elect or displace any subject matter to be pursued in a division application. So our advice, I'll just share my screen because it is important that it is kept in mind, is that you should the advice is not to exclude any embodiments from the set of claims. And I know that sometimes there is a budget restriction and you wish to save costs with examination fees. But for example, the advice may be to merge dependent claims as much possible, but keep all independent claims and embodiments so that during the prosecution, you are able to manage all your needs. And obviously, last but not least, to redraft unpatentable matter into patentable matter. We have a very usual issue on patent applications in the pharmaceutical area are the therapeutical methods, which are for use on human or animal body and therefore are not considered to be inventions. So in Brazil, the appropriate manner to redraft a therapeutical method is by the Swiss type use claims format. So, and we advise that, and we draw the attention to that, because sometimes the applicants file the application, but has no idea of what commercial product will be. Therefore, if the claims are too restricted or not all possible embodiments are covered by the set of claims, when your product goes to the market, so the applicant will find out that the set of claims does not cover the product and is faced with such an issue since there is no second chance. And unfortunately, it's not possible to rewind and go back in time and do things right. But there is a light in the end of the tunnel if it occurs. In case the applicant does not succeed to revert the Brazilian PTO negative opinion to get the coverage of interest, there is the alternative to continue fighting for patent coverage through the court's review. Because in Brazil, the Brazilian PTO does not have the final say about a patent system, as the courts are fully competent to review and to overrule the Brazilian PTO's decision in their entirety. So that's all, Ivan.
Okay, thank you, Monique. In the interest of time, I'll ask Ankush and Alexander to try to respond in within 5 minutes each. So Ankush, please, you have the floor.
Thank you. Amendments, actually, we, as a matter of practice, I'd say that given the the vagaries and the complexities which are associated in surrounding amendments in particular, a one-size-fits-all situation doesn't really work. So when whether it's voluntary amendments, I think we, and when I say we, I'm obviously referring to the attorneys at the firm. The attorneys would, you'd study a case, you'd look at the merits of the case. I think we'd also try to come up with a strategy, because under Indian patent law, there's a long list of exclusions, and you don't really want to get into a situation where you're trying to amend it in such a way that, for instance, you have subject matter that is not patent eligible. You try to amend it in a way that you trigger an objection under section 59, and then the amendments are not being allowed. So for each case, I think a strategy needs to be formulated. The Indian Patent Office also has certain restrictions in the sense that claims, once they are deleted, many of the controllers, the officers who are there at the Patent Office, they don't allow reinstatement of deleted claims. The opportunity to amend, has to be looked at very carefully. We also many a times look at the counterpart applications, see what kind of amendments have been preferred in counterpart applications, whether it's really beneficial to do that, keeping Indian law in mind. Really, you'd have to look at overall what are the merits of the case and whether amendments are really necessitated. And we'd only advise amendments if they're absolutely essential, or we believe that they're sort of going to expedite examination, or unless the client is very insistent that, or the applicant's very insistent that we must go ahead with, because typically you have the opportunity to amend when you're filing a response to the office action. And if those amendments are deemed unsatisfactory, then the Patent Office will again issue what we call a hearing notice. So you have oral hearing proceedings before the Patent Office where you get another opportunity to make further amendments. So from that perspective, voluntary amendments are something that we sort of we don't really sort of try, push or advise unless they're absolutely essential.
Okay, thank you. Alex, can you tell us
I'll
about
try.
the EPO?
I will try to be brief. As I said, this amendments topic is very important. Even if the EPO allows in the examination stage amendments, and later on in the opposition stage find that it's not okay, you will probably use the whole patent. So it is important to be careful. There are so many questions, and we are well prepared to help your clients along with individual advice. But let me just share the screen again, because we were discussing also the timeline quite a bit, and this timeline as well has a few restrictions which you have to keep in mind. One of the restrictions is that you are supposed to wait until you receive your European search report, because only then you will be allowed to amend description and claims as well as drawings. You have a good shot to do amendments, even at the early stage when you enter the European proceedings, due to Rule 70 and Rule 161. As I said before, later on, it's only with the consent of the examining division. So wait until you receive it. Be careful that you get all subject matter searched, because later on you will not be able to refer to it unless it has been searched. So if you get a unity objection and are allowed to pay additional fees for the unsearched subject matter, you should think about paying it to get it searched and then refer to it. You, as usual, will probably have to think about the examiner's reasoning and decide which way to go. You will always have to be careful to fulfill the gold standard and the therewith tied intermediate generalization and the essentiality test. So at the end of the day, it will always be important to stay along the framework given by the EPO. So I hope this answers your questions. Please feel free to add something or ask for something which I can add.
Yes, okay, thank you, Alex. Since we are almost running out of time, we could really explore this topic for another hour easily. Unfortunately, you don't have this time today. I have one question from one participant, which is just on the side of the issue of amendments, but I think it's also important. He's asking about whether the Indian Patent Office has any restriction on claims filed in divisional applications, possibly similar to the restrictions in Brazil. So perhaps, Ankush, you could give us just a very brief response to that. And Monique and Alex can also comment on whether there is any difference about the kind of changes you can do to your claims if you decide to divide the patent application instead of trying to amend existing claims. Please, Ankush.
Thank you. Actually, we've unfortunately had a decision from the Delhi High Court on this very issue. And I am not in agreement with what the court finally had opined. But it turned out, so I'd take a few minutes to just briefly explain the facts. What had happened was that we tried to, we amended the claims in the parent application, and essentially it kept hitting the Section 59 objection, like I mentioned. The controller was insistent that it's not falling within the scope of the original claims, and so we decided to pursue those claims, the amended claims. We decided to pursue those in a divisional application, and unfortunately, our arguments were that since the amendments had never been considered, essentially novelty, inventive step, all these, clarity, definitiveness, nothing had actually, the claims had never been examined, other than to say that the amendments were not considered allowable. And so we tried to push those in a divisional application, but the court essentially held, and so this goes back to a particular provision in the Act, which is section 16 of the Act, which deals with divisional applications. So under our law, you could file divisional applications on your own, which is suo moto, or you could file a divisional application if an objection is raised by the Patent Office. Now, the number of applications that actually go through on the suo moto basis is actually very slim. It's that is not to say we've been successful in the past. There have been some divisional applications that have now been allowed. The underlying criteria, whether it's suo moto or it's an objection which is raised by the Patent Office, is that there has to be a plurality of inventions. And so in this judgment that I was talking to you about, which came out from the Delhi High Court, the Delhi High Court actually held that the plurality of inventions is actually to be looked at in the claims, the original claims of the parent application. So when you're dividing an application, essentially that plurality, if you're making even a suo moto application, you should be able to establish plurality from the original claims of the parent application. So that's essentially a restriction which has been placed, which of course I'm not in agreement with, because the plurality, if you read the provision, and again, section 16 is one which is it's a fairly clearly worded provision, but the way it has been worded is the objection, as far as the plurality objection goes, that is somewhat more tied up with the with the controller's objection, and the fact that you're reading that plurality into the original claims of the parent application seems to be a very restrictive interpretation. So suo moto, as long as you can establish that there is another invention that exists, and it not necessarily in the claims of the parent application, but even if it's there in the disclosure or the specification, in my opinion, that should be good enough. But unfortunately, that's not what the Delhi High Court thought. So,
okay, thank you, Ankush.
And just to add on to that, we actually pressed the applicant to sort of, because this was a very important decision which had come out, and we actually tried to convince the applicant to go in and appeal, but for whatever reasons, the decision was not appealed. So that's the current standing as it stands.
Okay, thank you. Alex?
Yeah, I did like Monique's slide, because I just screenshotted it and tried quickly to show where the difference concerning, well, in comparison Brazil and Europe would be. And I just tried a quick sketch, and well, the first important step in time or time is the ESR. Then afterwards, obviously, more is allowed in the EPO than in Brazil and even in India, if I got it right. But then later, if we have the grant, it gets more difficult, as we have this Article 123, brackets open 3, brackets close, or third paragraph comes on top. But actually, as long as we keep the gold standard in mind, we can amend quite a bit, even new claim categories, even broadening the scope of protection if you are in the examination phase. Afterwards, no longer. But there are obviously some possibilities which you have. So that's what I took on from my side. And one message very important for me is be careful. If you make amendments, preferably go for explicit disclosure. Be careful of the context, and always have in mind that at a later possible opposition proceeding, the patent in full is endangered if you do something undue concerning amendments.
Okay, thank you. Just one question, Alex. You mentioned that the applicant should be careful not to introduce claims for matter which was not searched. Is that right? Would a divisional at this point a solution? If
Yes.
you have, of course, if it is in the initial disclosure.
Yes. We were discussing, Ivan, quite a bit this unity problem, and one of these results of the unity problem which we have in Europe is that they are not going to search for inventions not belonging to the one invention. So then you can pay them for doing the search, and you are free to move the invention from the one to the other in the parent case. But if the client is not willing to pay at that stage, because, for example, the second invention is not important, he later can, of course, file a divisional and get it searched again. Yes, you can do so.
Okay, thank you. And Monique, about Brazil and divisionals, you're on mute.
Yes, the same problem. Just one comment, Ivan, regarding divisional applications related to this question is specifically, yes, today we have shown that how important is the request for examination in Brazil specifically. But we would like to draw the attention to Article 26 of the Brazilian PTO, which defines what are the conditions to file a division application. So the conditions, the requirements to be met are: the patent shall be filed until the end of examination, which is considered by the Brazilian PTO to be the allowance, rejection, or shelving of the application. Refer to the parent application and does not exceed the subject matter disclosed in the original application. So we stay on the same path here, bringing the importance of having the matter claimed disclosed in the original application. So once we have all these requirements met, I think that it is quite easier to bring the matter, for example, to before the federal courts and discuss the matter. So because in the situation, the division application, all the requirements are met. So the strict position adopted by the Brazilian PTO regarding amendments of the parent application are brought to the division application. So once we have this scenario, and specifically we have met the requirements for division application, I think it makes our lives easier when bringing the matter to discussion at the courts.
Okay, thank you, Monique. Well, we don't seem to have other questions from the participants. Let me ask you, Ankush, about the effects or the impacts of this recent decision by the High Court in Delhi. My impression was that it does not change the application of the law in a very large extent. It seemed to me that number one, I think the impact might be in the sense that if I understood correctly, and you can correct me if that's the case, that the interpretation of the judge was that the claims are actually part of the specification, because there is I think it's on the rules saying that the contents of the specification, that every complete specification show, and then you have the definition of and with a claim or claims defining the scope of the invention. I have the feeling that when I read this, that the claims are part of the specification and they cannot be disconnected when you are speaking about what kind of changes you can do to claims. And the other thing is that it appeared to me to be important is that the change from the use of an implant to the implant itself was not considered to be substantial in this case. Can you briefly comment on those 2 points?
Sure. I just go through very briefly what the facts were. Actually, this was so under our law, we have a provision where methods of treatment are not patentable. This was an application, of course, which was hitting that roadblock that the subject matter is not patent eligible. And so we were from a method of treating an eye condition to the implant itself, which was to be inserted into the eye. That's essentially what the change was. Now, the patent office essentially was of the opinion that what you are essentially claiming is a method or a process, and you define the specific method steps or the process steps of how you go about with that method. In the claims, you've essentially, while you have disclosed the fact that you are using an implant, what you're trying to claim is, so the original claims were a method or a process claim, and now you've moved to a product claim. So you're completely changing the category of the claims. And so that is something that Section 59 should not allow, because it says that the amended claims should fall wholly within the scope of the claims. Now, in order to sort of convince the judge, we went through all the claims which were there. The support was shown in the original claims, although the preamble of the claims was with a method. So, but there were features of the implants which were disclosed in the claims. So we invited the judge's attention to that. And not just that, we tried to show extensive support in the specification. And so what the ruling came to be was that simply because you're changing a process claim to a product claim cannot be considered as a reason to shut down any amendments at the preliminary stage. So essentially what had happened was, because of the change in, you move from a process to a product, the controller at the patent office said, these amendments are not going to be allowed, so I'm not even going to bother examining the novelty and inventive step and other aspects. And so essentially that's what the court has done. What the court said was, you cannot shut down, especially because you have to look at what is the intention of patent law. It's to foster inventiveness and not to discourage it. And so when you look at the claims, of course, you can see the support not just in the claims, but you can also see the support in the specification, and an overwhelming majority of the specification actually talks about the implants. So this used to be the position earlier. The patent office did used to allow, because methods of treatment have never been patentable in India. They used to permit, there was a stage when the patent office did permit you to change, convert method of treatment claims into composition claims or device claims or whatever the treatment involves. That was essentially, that aspect used to be allowed. But somewhere along the line, the Section 59 sort of got highlighted. And so then they just started refusing applications left, right, and center. And so the court basically looked at the fact that, there's a lot of research and development. There's a lot of, investment and expenditure which has gone into creating even this product. And so it allowed the amendments, but it sent the matter back to the patent office and said, the criteria of novelty, inventive step, clarity, definitiveness, all those factors still need to be satisfied. So it's essentially, the amendments were allowed, but again, the matter is again back at the patent office, and of course, subject to the applicant being able to demonstrate all of this, of course, the patent would be granted. So that's essentially what happened in the case. And I'm sorry, I would like you to just sort of repeat your questions if you don't mind, Ivan.
No, I think I can summarize my question in the sense that, will the Indian Patent Office change the way they apply Article 59, considering the High Court decision?
And that's something that remains to be seen, because it's not just this judgment. There was another judgment which came out somewhere in middle of 2022. And in that particular case, again, the applicant started with product by process claims, and then they essentially converted those product by process claims, and they sort of restricted the scope to the process aspect. And again, the patent office again raised the Section 59 objection. They said, you were initially claiming a product, even though, defined with process limitations, but you were essentially claiming a product. Now you're claiming the process. Again, that's hit by Section 59 because you're trying to change the scope. The judge took the view that you are actually restricting the scope. It's not a broadening of the scope, and that's again very important to look at from the facts of each case. You're not broadening the scope; you're restricting the scope, and and the judge went ahead and actually looked at what was the intention of the lawmakers. There was an extensive discussion in that judgment as well. And there was even the Article 123 of the EPC was taken into consideration. They looked at those provisions for guidance, and essentially the sum and substance of the judgment was that you have to interpret the provision was never intended to be interpreted restrictively. A broader interpretation, a liberal interpretation, should be given, at least prior to grant. Perhaps post grant you may be more restrictive, but at least prior to grant you have to allow applicants to make those amendments. And so it needs to be seen how this practice would change between different offices. I can tell you that I have at least 3 or 4 more cases on Section 59. So I'm looking forward to using these precedents and hopefully get those cases allowed as well. But we now have, there are 4 different patent offices in each of the metropolitan cities. So these decisions which are coming out from the Delhi High Court will take some time before they sort of percolate down in the different offices. One very welcome news is that we have the Madras High Court in the down south has now created an IP division as well. And so we'll be looking forward to some interesting decisions coming out from that particular High Court. And it will be interesting to see, if they're at divergence with the Delhi High Court, or they're arriving at the same findings. So it's a wait and watch situation.
Yeah, thank you very much. I'm looking forward to hear more about this. It's really a pity that we don't have more time to continue discussing of issues of amendments and divisionals. So I'd like to thank very much to our speakers, to Ankush, to Alex, to Monique, to Patricia for the introductory words, and to all the participants. So thank you very much, and bye-bye.
My
Thank
pleasure.
you. Bye-bye.